let's talk about geographic limits and the effect of registration. So the effect of registration is that it mitigates the concern of the T. Rose doctrine by addressing the problem of remote junior users innocently using someone else's mark without knowing that there is a senior user that is out there. When you register your mark, you are giving constructive notice to the nation that you have trademark rights in a particular word, name, symbol, device, what have you. And now that concern is mitigated. And what registration does is it gives the registrant nationwide priority compared to any later user of the mark in question. And it doesn't matter what the senior user's territory is, because now junior users no longer have a defense that they in good faith adopted the mark without knowing of the senior user's trademark rights. This raises the question, of course, what about prior users? And the answer there is straightforward. To the extent you have someone who is using a mark before registration, they retain their common law T. Rose rights in their area of use, but they no longer have free rein to expand into other territories of the United States where the senior user may not be found now. Even though the senior user may not be found in all territories of the United States, they have priority to every one of those territories, with the exception of areas of prior use by third parties prior to the senior user's registration. And so this is illustrated by the Don Donut versus Hart's Food Store case. In Don Donut, the plaintiff registered their mark in 1927. They renewed in 1947 and acquired rights under the Lanham Act, which was passed that decade, of course. The junior user began their use in 1951, and at the time, the plaintiff was not using the mark in the defendant's market area. And so can the defendant bring the T. Rose defense? The answer, of course, is no, because the plaintiff had national priority under its Lanham Act registration. Now, the defendant tries a regional abandonment argument. We'll cover abandonment in a later lecture, but just basically says, well, the plaintiff was in this area, but then they left, and so they abandoned the market, so it should be okay. And while abandonment is a potential claim that can be brought against a trademark holder, there's no such thing as regional abandonment. If you're abandoning your mark, you have to abandon it everywhere. You don't lose out just because you make a business decision to maybe cease operations in a particular area. And it would just be too difficult to administer a regional abandonment standard in any case, right? I mean, how do you measure the geographic extent of an abandonment? So that is out. But interestingly, and this is the so-called Don Donut rule at work, the court refuses the injunction, saying there still has to be a likelihood of confusion. And at the moment, the plaintiff and the defendant are in different geographic markets, and there's no likelihood of confusion. Now, the plaintiff may later, upon a proper showing of an intent to use the mark at the retail level in the defendant's market area, be entitled to enjoin the defendant's use of the mark then. So the junior user may very well be on borrowed time, but in the absence of an actual likelihood of confusion, the plaintiff does not get to enjoin the defendant at this time. And so I think this is arguably reflecting a view of trademark rights, again, as being kind of more like a tort. Are people actually being confused by the defendant's conduct, implicitly hurting the plaintiff's business, and not this idea that the trademark is some kind of property right that the defendant is, in effect, trespassing on. There is no metaphorical trespass until you actually have the harm of the likelihood of confusion. And so, as with a lot of other aspects of geographic rules that were crafted decades and decades ago, some courts have questioned whether or not the Don Donut rule makes sense, this idea being we're in a more mobile age, and maybe confusion is more likely even in a market that is relatively remote. And so some courts have raised that perspective. Another issue that comes up in the context of Don Donut is one of laches or acquiescence. And you might wonder, if there is somebody operating with the same mark as the plaintiff, in an area where the plaintiff would have priority under its registration? Does the failure to act create the possibility that at some point in the future, the user of the trademark will resist a claim by the plaintiff by saying, well, I've been doing this for decades, you never acted, and so you've acquiesced, or the doctrine of laches precludes your suit. And so this has come up in a case called Whataburger of Virginia versus Whataburger of Corpus Christi. And there the Fourth Circuit said there's no duty to actually sue until there is an actual likelihood of confusion. And until there's an actual likelihood of confusion, there's no laches or acquiescence. Another interesting issue that can come up in the context of registration is what happens if somebody is the junior user, they're the second user of the mark, but they're the first to register. They get to the trademark office first. Now, if the registration is contested, then we have what should in most cases be a simple answer. The first to use should be the one who gets the registration. But sometimes you may find yourself in a situation where the junior user is unopposed and the junior user gets the registration. In such a context, the senior user retains their rights in their area, but the junior user may effectively freeze the senior user to its territory if the senior user didn't actually act to stop the junior user from getting the registration. Now, if the senior user wakes up and tries to cancel the registration and does so before the mark becomes incontestable, it can get that. But once the mark becomes incontestable, something we'll cover when we talk about registration, then that becomes impossible. Now, sometimes you'll have these things called concurrent use proceedings, where the trademark office tries to allocate markets to two claimants to a mark. Usually there's a preference for the senior user in proceedings of that nature, but sometimes that can be overcome by other factors, the activity of the junior user, who was the first person to register, agreement of the parties, pattern of the use, that kind of thing.